together. Here I am with Attorney Maricel Alvarado, friend to all dreamers, and Sarah Monty. And here we are, at the beginning of this year, we made a commitment to all dreamers, all DACA holders, that we would be holding these seminars every 3 months until, because there's so much happening in this area. And actually, just so you know, we are holding seminars every 3 months in the area of family immigration, humanitarian immigration, which I believe we're going to be doing that later on this month. Is that correct?
Correct.
We are also going to be offering a business immigration, updates under, Trump 2.0. And of course, this is one for DACA and Dreamers, okay? And so today what we're doing is we're kind of putting together the two aspects of how a dreamer or a DACA holder can actually leave that dreamer DACA holderness and go into another status, right? And so what we've done is we've got kind of an ambitious schedule. Attorney's going to be talking about family-based options. And then I'm going to go ahead and talk about the employment-based options, okay? So that's what we're going to be doing here today, okay? Go ahead and move forward, Attorney.
All right. So welcome everyone. And as Sarah mentioned, we're big supporters of Dreamers and DACA recipients. So we try to stay on top of what's happening and also just trying to be creative and strategize on ways to help DACA recipients gain status one way or another. And so, but I'll start with what is going on with DACA today. As of January 17th, 2025, we finally had a decision from the Fifth Circuit Court of Appeals, which decided to uphold the lower court ruling on DACA, specifically saying that it was unlawful, but they had certain limitations that applied to Texas. Okay, so the first thing that this ruling indicated is that, of course, that DACA recipients that already have it can continue to renew, but they intended that Texas was the only one that could really prove damages here in this case. And so what they opted in that order is that Texas would be the one that would lose the benefit, or the DACA recipients of Texas would lose the benefit of a work permit. As of right now, that still hasn't been implemented. So although that was an order in the decision, USCIS has to actually implement it, and that has not happened. And then, of course, as of right now, they continue not to allow new applicants to apply for a DACA. And so what we expect as of right now, that this will again go on to continue to the Supreme Court, which would mean that we would potentially have a hearing later this year or early next spring, and of course a decision that will come after that. And so the big thing right now is that we can tell DACA recipients, obviously, go do a consultation, figure out what all of your options are. And so we're going to kind of go over some of those strategies that we go over with clients. So Sarah, if you can go to the next slide. The next one, please. All right, so I'm going to kind of give you a little bit of a roadmap of what the family-based process for a DACA recipient could look like. And of course, Sarah has already mentioned she's going to go over what that would look like in the employment-based. And we would want you to kind of, look at both options to see if one is that would work for you, right? So right now we're going to kind of go over what the overview of a family-based process, like what do we look for when we're analyzing a case. We're going to go over the changes in advanced parole. What are the risks if that is an option for you in order to pursue a family-based green card process, and of course going over unlawful presence if advanced parole isn't an option in order to obtain, or is it an option based on that you don't have an immediate relative, or humanitarian reason to apply for advanced parole. Okay, we can go to the next slide.
Okay, great. And I'm doing map 2. And again, here we're doing employment-based options, but here we're only looking at non-immigrant visa options. And one of the reasons we're focused on that is that those of you who are living in this employment-based world, we have a backlog of an immigrant visa backlog, which just makes it a lot more complicated. It's really, there's not a lot of options here unless you're extraordinary. I mean, and by extraordinary, more extraordinary than your mother thinks you are. Here I'm talking about someone, who has extraordinary abilities. So what we're going to be talking about here is the degree holding DACA recipients, okay? And degree holding dreamers who are not eligible for family-based petitions. Well, then, there's some people that, they can't go and they don't have a US citizen, somebody. And so they're having to look other ways. And so this is what we're looking at. I do think it's really important for us to really understand this 3 and 10-year bar issue if you're looking at this, because see, that's the nice thing about the family-based. You've got matter of Arabelli, which says an advanced parole entry is a good entry and it doesn't trigger the 3 and 10-year bar. Unfortunately, we don't have this in employment-based, but we do have something. It's a 212D3, which is something for real. It's something that, bless his heart, President Biden didn't invent. It is actually an established part of the law. We're going to talk to you about how it works. And then we're going to be talking a little bit about overcoming the legal obstacles, which is a 3 and 10-year bar, how to use the H-1B plus advanced parole for those people that don't won't be triggering the bar, and then H-1B plus 212D3 and the waiver. And we also are going to tell you why H-1B is the key in this, okay? So go ahead, you take it away.
Okay. So in analyzing a family-based case, we always look at your history and of course your family's immigration history. So just in case you have a golden ticket hidden somewhere, we want to know if there's ever been a petition that family was filed that was filed either for you or for your parents that you might have, been dependent on, and that could potentially help you in waiving or forgiving unlawful presence, unauthorized employment, and of course, a legal an option to be able to adjust status in a situation where you have an immediate relative. So we always look at that an immediate relative, and family preference categories, or even employment-based options. So this petition from this date would allow you to not have to leave at all. And, obviously we look at to make sure you don't have any other inadmissibility, so criminal, permanent bar, things like that. But this is what we would call the golden ticket. So that was always one of the first questions that we want to analyze. And this is an important question to ask your parents. Like, have you ever had an immigrant petition? And you would be surprised how many consultations that I've had with DACA recipients, and I ask them about their parents, and especially if they have status, that they didn't know that they could benefit from this, due to maybe they've aged out, so they didn't get to benefit from it initially. But this is a way that we've been able to even to go through the employment-based process. Okay, next slide.
Can I just throw something in there? Even asking about those U.S. citizen grandparents. That's another thing that we'll talk about at another time. But if you've got one of those, they might come in handy.
All right. And so, and again, these are the questions to ask to determine whether in a family-based process, are you able to adjust status or consular process? And consular process means you're going to an immigrant visa abroad, or whether you're going to be able to obtain your status right here in the US. And so, of course, for an immediate relative, which means a US citizen child that's over 21, or a spouse. And unfortunately, your parents, if you're already an adult, don't count, and neither do your siblings for an immediate relative category. But for that category specifically, you need a legal entry. That's all you need all you need, a legal entry in order to be able to adjust status. Now, we still analyze, are there any other admissibilities where did your parents bring you into the country more than once when you were a child? Are there any, did you ever make a false representation upon an entry or things like that? But in general, especially DACA recipients that tend to have pretty clean cases, just have maybe the one entry that where you were brought in when you're a child, we determine, was that a legal entry? Are you able to, just continue on with your process in the US? And then, of course, for employment-based or family preference categories, there's more involved in order to be able to adjust status, which means you have to have had maintained status into your entry, not have more than 180 days of unlawful employment, unlawful presence, and of course you have to have status at the time of filing in order to adjust status. So the issue here is that DACA recipients, the protection that they have is not a status. So these categories don't work for DACA recipients unless, again, the 245I, like I mentioned, because DACA is not status. And now, like I mentioned, we go through various things to make sure that you don't have any other violations or history that could impede in order to be able to adjust status or consular process. So again, we're going to ask you questions that maybe you don't know the answer to, that you have to involve your parents. But if you don't have that legal entry, there's the option of consular processing, whether in the family preference categories, employment-based category, which then you would have to potentially need a unlawful presence waiver. And we're going to talk a lot more about that. So I'm not going to go into detail because I know there's a whole section of that under Sarah's presentation where we're going to talk about it regarding the 212 D3 waiver. But here, we want to analyze whether if you, let's say, go the green card process through an employer, and we're not going to talk too much about that because we talked about the backlog. We're going to determine whether at any point during your DACA history, have you had any unlawful presence? And this is in the situation where we have to consular process. So we want to see all of your EADs, because if at any point there was a lapse in your DACA protection, that time in between is considered unlawful presence. And any time between your 18th birthday until, let's say, obtaining your DACA benefit for the first time is also unlawful presence. So we analyze that in determining whether consular processing is a possible route for you. Okay. Next slide. Okay, so in the family-based process, if we're lucky, we're only dealing with USCIS, but potentially we could be dealing with 2 other agencies, Department of State, if you have to consular abroad, and if you have a prior removal order, we would also have to be dealing with the Department of Justice. Go on. And so the goal is that we could get everyone to do a process in the US, just because there's always a little bit less risk if you're doing a process in the US. And then, of course, you get to get a work permit while you're waiting. And like we mentioned, the only case where you can use a legal entry in order to adjust status is an immediate relative. So this is mostly, we're talking to individuals who have a US citizen spouse or US citizen child that is over 21. And so if we have those options and we've never had a legal entry, is it still safe to apply for advanced parole? So now, what is advanced parole? Advanced parole is literally asking for permission to travel abroad, but it has to be specifically for a humanitarian or business reason. So it could be to study, for work, or visit sick family members. It doesn't just have to be sick family members. It can be medical reasons, say that you have, it's cheaper for you to go out of the country for a dental appointment, or even potentially visiting a gravesite of a a close relative, typically grandparents. Sometimes aunts and uncles, unfortunately, get denied. But those would be areas that I try to limit to. And of course, this allows you to take that quick trip out, come back in, and now you have a legal entry in order to adjust status in the US. Now, the big question has been, what has changed since the last Trump administration? As of right now, like we mentioned, the DACA program for individuals that have it, it's still in place, so they can still apply for advanced parole. Now, what's going on at the along the border or any airport is that there's just higher scrutiny and just higher risk for anyone that has had any kind of criminal proceeding or has had any removal proceeding as well. During the first week, I think that was the biggest panic. We were getting reports that people were waiting for hours as they were examining their documentation. But as the time has gone on, we've had people travel and they've been able to come back. But at the end of the day, it's so important to review your case with an attorney to make sure you're not a person with high risk. I know many of you might have seen a couple of weeks ago, there was an individual that applied for advanced parole, was approved, left, came back, and was not allowed back in because he had an order of removal. Which means my understanding of the case is that advanced parole should not have been approved by USCIS. It needed to have been approved by a different entity. But then he was allowed back in eventually because there was a lot of media and of course there were suits that were filed and he's getting his removal case reopened. But those are the risks. Those are the risks that if you have a removal proceeding that maybe whoever you're dealing with in CBP, because at the end of the day, you're not going to have your attorney there present. You might not have all of the facts of your case because maybe you have an attorney that's been handling your immigration case and all you have is advanced parole on your passport. It's harder to advocate for yourself. So important to talk to an attorney before you make the trip, especially if you have any of these situations. But what we are advising, if you do want to take the risk of doing that advanced parole, leave on a Friday, be back on a Sunday, because as you watch the news every single day, things change so fast right now. So less likely to happen over the weekend. Limit your trip to a Friday and be back on a Sunday, just for security. Okay, next slide. And like we have discussed in the past, any DACA recipients that have order of removal, meaning a judge has already decided at some point, you might have been a child, maybe your parents never went to the hearing, already have an order of removal. Those are the ones that are a little bit of a higher risk, right? And in the situation that I think the guy was from El Salvador, if I'm not mistaken, but in that situation, he already had an order of removal. In his case, they were managed to reopen it because apparently he didn't have notice or something like that. So some technicality. But those are higher risk. It doesn't mean that you're not going to be able to come back, but it's all about the risk level. And what I've been advising clients, because I've had clients that have done the advanced parole in the Trump era with removal orders and have made it back. But what I suggest is that you have your backup plan. If you don't have an affirmative relief that you can apply for, then it's probably not best that you travel. So what we've been doing, if let's say the individual has a U.S. citizen spouse or an adult child, or I want the I-130 already filed before they take the trip, because if something happens and they're not able to come back on the advanced parole, at least we know that that case is already in process. And okay, there's for some, we really can't, because things have changed. Let's say DACA ends while they're out of the country. We know that we are able to continue with the case abroad. Okay, and everything gets a little harder if you don't take care of those things before your trip. And then, of course, just to kind of go over what happens if you take the trip, you come back. Well, we do try to get this reopened, to have a judge decide to terminate it, and then, of course, being able to adjust that. So we still have to deal with that order of deportation if you manage to, take that trip and come back, which that is also getting a little harder, but it is still possible. It's just a lot of risk. Next slide. Okay. And here, if you have removal proceedings that were administratively closed. So what tends to happen when a case is administratively closed? What does that mean? So this is someone that was placed in removal proceedings, but it was basically put on pause, and meaning it was put on pause because you have some other benefit or some other humanitarian reason. For DACA recipients, let's say you were put in proceedings before DACA became available, but then you were eligible for DACA, and the judge decided, let me close your proceedings while, until, let's say, until you don't have that benefit. But if you travel, again, still a risk, but you don't actually have a removal order, you travel, you come back, we have to then reopen your case and try to get this terminated in order for you to actually proceed with your adjustment of status in the US. Next slide. Okay. So let's say we don't want to risk the advanced parole. Does it mean that there isn't a solution if you have a qualifying relative, such as a US citizen or permanent resident spouse, adult children, or maybe your parents filed a petition for you a while back and your priority date is becoming current? Well, then you can move forward with potentially filing a waiver. Again, but the only people that qualify for this waiver are people that are married to a US citizen or permanent resident, or have parents that are US citizens or permanent residents. And again, if first you've had DACA since you were 18 and you've never had any lapses in your DACA protections, then you probably don't need a waiver at all. So we do have some clients that have been more reserved on traveling, even, on the advanced parole now that Trump has come in. But if they don't want to risk the advanced parole, would still potentially be an option, whether to consular abroad, take that trip, if they haven't had any unlawful presence. But only those that do have unlawful presence, this is the only way to overcome that. And we have to show that those qualifying relatives are going to suffer extreme hardship, which includes medical reasons, emotional, physical, economic, and of course we look at country conditions. All right, next slide. So I won't go through all of these questions, but again, it's just a reminder that when you're going to meet with an attorney, of course, meet with an attorney, see what all of your options are. You want to know about your immigration history. You want to know about your parents' immigration history, and even your parents or your grandparents. Like Sarah mentioned, sometimes maybe one of your grandparents was actually born in the US, and although they lived their life in Mexico, had your parents there, and then your parents had you, maybe there's a way that we can make that citizenship come down the line. So ask about those questions. Have all of your DACA approvals in hand, so that way an attorney can determine whether there's any gaps, whether unlawful presence is something we have to overcome, or we can just move forward with consular processing without having to do advanced parole if that is something that you feel safer with. All right, and I think the next part is you, Sarah.
Okay, great, thank you. And so this is employment-based, and employment-based, the employment-based immigration goes by different rules, okay? It goes by different rules, and we're looking at different aspects of it. Again, this is what we're looking at, those people where they really won't be able to have the option to have a spouse. Maybe they're already married, maybe they can't find the love of their life for whatever reason. Well, let's look at the degree. Here, that's a real opportunity for some people, okay? Okay, so before we go any further, this is critical for employment-based cases. This is probably the number one reason that either Dreamers or DACA folks, and again, you're probably saying, well, why does she say Dreamers and DACAs? Well, there's a difference. DACA people actually have the protection from deportation, and they actually have the employment authorization, okay? Dreamers, there's a lot of Dreamers that never got the opportunity to file for DACA, that they were either too old or too young, okay? So that's what I make that distinction, okay? So this 3 and 10-year bar, this is the reason that most people have problems, okay? So if you've been in the US, you came in, whether it was legally or without permission, okay? You made an entry and you stayed here for more than 180 days without permission, okay? When you leave the US, you will trigger a 3-year bar. Basically, the government will say, hey, you go and apply for a visa. They go, hey, go away. Wait till 3 years have passed. Because by you leaving, you've triggered that bar, okay? Remember, this is not with the DACA advanced parole. The DACA advanced parole doesn't trigger that bar, okay? This is for people who are not, who don't have the DACA advanced parole. And if you've been here, okay, likewise, if you've been here in the US for more than 1 year, whether you came with permission or without permission, and you leave, what do? You trigger the 10-year bar, okay? So this is the problem that people have, is that they can't do anything because if they go and apply for the visa abroad, they trigger the 10-year bar or the 3 or the 10-year bar. So this is our obstacle, but this is our conversation today is going to tell us how we overcome this, okay? So the way that this is can be overcome is by this. It's called a D3 waiver. Now, this waiver is only for non-immigrant cases, meaning if you're coming to the U.S. as a non-immigrant, employment-based, okay? Attorney Maricela was talking about a waiver. That's another waiver. That's the I-6018 waiver. This one is only meant for non-immigrant visa cases, okay? So this is part of the existing law. This is something that's existed forever, okay? So it's there. You need a non-immigrant visa. We're going to talk about which type. You don't need a qualifying U.S. citizen person or a legal permanent relative, okay? You're doing this based on, as we propose, through employment-based petition, okay? What's also interesting and wonderful about this, the waiver standard is not all crazy. It's very obtainable, okay? So let's see if this does provide any hope for us under the D3 waiver, okay? So we're going to be looking at the waiver before we look at anything else. Let's say I have a degree. I get my H-1B. I'm hired by a school district to be a teacher. They spend the money on me. I get an approved petition, okay? That sounds great, but what happens? When I leave the US, I'm going to trigger that bar, okay? This D3 waiver the waiver is like a pardon, can pardon that 10-year bar, okay? And this is the standard. The law looks at you and looks at the risk of harm to the society if the applicant is admitted, okay? So you came here when you were 2 months old. Your parents brought you here when you were 2 months old. What is your harm? Your harm is, well, that you came here as a child and really that you stayed here. Of course, you were a child. You didn't have much choice. You got your degree, you were excellent, and you got somebody to offer you a job and to file the petition. So really, the harm to society is minimal, right? Because what have you done wrong? Okay. So the risk of harm to society, that's weighed against the seriousness of the applicant's prior immigration law or criminal law violations, if any. Here, we're talking about DACAs and Dreamers without any criminal issues. So really, the only thing that you did wrong was basically be born in a different country. Your parents brought you here, and now you want to progress. You've got a degree, okay? Uh, then they look at what are your reasons for wishing to enter the US? Well, the reason I want to enter the US is that I've got an employer that is sponsoring me for an H-1B visa. I want to come and teach kids like me. Okay. This is what the law is supposed to look at. And if you look at that, for most DACA or Dreamers that have a degree, that have gotten an employer to sponsor them, this is very attainable. This is very attainable. Okay. Again, before he left, Biden actually added something to the Foreign Affairs Manual, which is it's a publication which is used to provide guidance to the Department of State. And here they made a special addition to talk about to the visa officers if you've got a person that has triggered a bar in this case, and to discuss the possibility of the D3 waiver. Okay, so that was added to the Foreign Affairs Manual. Okay, so D3 waiver, you've got it. The risk is you're going to have to leave, because if you're here in this country without status, if you don't have an old petition, a prior petition, a legal entry, okay, you can't obtain status in the US. The only way you can obtain status is by leaving. And it's a catch-22. If you leave, what happens? You're going to trigger the bar. But there is relief possible for cases where you've got a visa available to you, you've got an excellent record. So this might be a an avenue. Okay. Okay. So now I'm going to be talking to you, instead of going backwards to frontwards, I'm actually going to be telling you what this looks like. Okay. What this looks like. And let me just say this. When I'm saying this, we are living in the Trump era. And we're living in, Trump era 2.0. I don't want people to think that I'm, telling you to, read this and go do this by yourself. No, you need to get counsel. You need to really understand what the risks involved are. That's very important. You need to read a lot. At the end of this presentation, I'm going to introduce you to a wonderful organization, which is called A Path to Papers. And we've actually recently had the opportunity to speak to them on cases. These people are right at the cutting edge of using this D3 waiver to bring DACA holders and Dreamers into the US and to put them into a status. So that is what I got to say there. Okay, so what happens? An H-1B petition, and you're going to find out why H-1B is my choice. The employer files an H-1B petition, okay? You're going to have to get an employer to get crazy about you, and so much so that they file an H-1B petition. Okay, there's, you probably have kept up with the H-1Bs if you've heard about it. It's this crazy visa that they only have 65,000 visas issued a year, and there's a lottery and there's madness and crazy. Yeah, and I think you're probably saying, oh, God, why does she want me to do all of that? And that's a good option, but I want to tell you one thing. The H-1B visa, there's two different types. There's one H-1B visa that's subject to the numerical cap. That's the visa that everyone stands in line for in March, and they get into a lottery and they see who wins. But there's another H-1B visa, which is cap exempt, and that's given to certain employers such as hospitals, schools, universities, okay? So not all H-1Bs have to wait in line in March, okay? We'll talk about that in a bit, okay? Now, if you are lucky enough to be a DACA holder, okay, we do recommend that you actually apply for the DACA parole. Okay. That way, if things don't go the way they should be, you've got a pass back. Okay. Remember, leaving the US, you trigger that 3 or 10-year bar. Okay. But the idea is if you do trigger that bar, you have in your back pocket the D3 waiver. And that D3 waiver, what is it you have to show? What terrible sin you committed by coming here at the age of 3 days old and staying here and being lawful and getting a degree is outweighed by all the good that you're going to come and do. Maybe you're coming in to be a teacher. Maybe you're coming in to work in IT in a hospital. The idea is that here you are coming in to give benefit to the U.S. Okay, and so that's what they're looking at. Okay, now the only non-immigrant visa options that really the ones that are the strongest options that you can combine with the D3 waiver are really H and L and to some extent O. H-1B and L, those visa classifications, the reason that they're ideal for this is that the H and the L allow for dual intent, meaning when you go and apply for the visa abroad, for lots of visas, you have to show that you're not coming to the US to stay. That is not the case with the H or the L visa. That H and L visa allows you to have dual intent, the intent to come here, for a little bit or forever. Okay. And if you are a dreamer or a DACA holder, it's going to be very hard to convince the officer that you've lived here for all of your life, but the 2 months that you were, that you lived in El Salvador as a baby, it's going to be very hard for them to believe you're not coming to stay. Well, if you have an H-1B or an L, you don't have to prove that you're only coming for a little bit. Okay. We won't really get into the L because that's kind of a quirky situation. I guess it would be possible. And if any of you are interested, we'll discuss that. That's actually kind of nicer. But you've got to have a certain circumstance. Let's not get into that. Now, there is, and in talking, there is actually also maybe not a stronger case, but for those 01 folks, here among our dreamers and DACA holders, we've got physicians. We've got maybe scientists who came here at a young age. They got a degree, they did great, but they haven't been able to really work in their areas of a specialty. Or you probably have more in the case of maybe you had physicians that came in on an F1 visa, they fell out of status, and now they're wanting to get back into status. Well, the D3 waiver might get this to happen, okay? But these are the visa classifications that really are ideal for this, okay? Okay, what are the advantage of the H-1B? If it's quick, it's a quick process, okay? Dual intent allowed. We talked about that. Okay, there's no need to show a permanent residence abroad. The initial approval is 3 years with an extension of another 3 years, okay, for a total of 6 years. But I'll tell you how we can extend beyond the 6 years in a little bit, okay? So those are the advantages. It's not something that you have to wait for months and months and months. It's relatively quick. What are the disadvantages of the H-1B? It's only available for individuals who work in professions that require at least a bachelor's degree, okay? So you have the position must, in immigration talk, be a specialty position, require a degree, okay? The other disadvantages, we talked about that. For a lot of the H-1Bs, there's just a few of them, okay? There's just a few of them, unless you go to those employers that are given special blessings and are allowed to use the H-1Bs that are not subject to the cap, like can be school districts, universities, hospitals. A disadvantage is it's a real expensive visa, okay? It's a real expensive visa, which must be paid by the employer. So the employer has to be in love with you to spend a lot of money on you. That's a disadvantage. Most employers won't do that unless they know you. Here again, the DACA folks have the advantage. If you have an employer, you've got employment authorization through your DACA. Your employer has had a chance to fall in love with you. They understand what you need. That you are in a very, very good place to convince an employer to go through this process for you. Okay. Again, dreamers, you're at a disadvantage because you really, really got to impress the heck out of somebody. And the employers have to understand this process, which is complicated and gets more complicated if you add the D3 waiver on it. Okay? Okay. So in this process, and again, I told you there's two different H-1Bs, the ones that there's only 65,000 issued a year, or there's those that are not subject to the numerical cap. These are the employers that, guys, you've got to go look for, okay? And institutions of higher education, government or nonprofit research organizations, profits formerly affiliated with a cap-exempt organization, such as hospitals, public and private elementary schools. So this is for those folks, that can't have a family-based option because they just don't have that U.S. citizen person, or they, they don't. In some cases, like in the case of the I-601 A waiver, the wait time is so long for that. Okay, this for those degree holding DACA recipients and dreamers, this can be an option for you to look at. Okay. So, we talked about triggering that bar. Okay. So let's say you're lucky enough to get somebody to file an H-1B for you. They file it for you. You're smart. You're good. The D3 is approved. Okay. You come back in. Well, I guess the bad side about that, you still triggered the bar. Okay. So what you have to do is you've got to be able to, that 10 years, you're going to have to wait out that period. So I guess one of the disadvantages for dreamers or DACA holders, if they triggered the bar, is that you're going to have to hope that employer really loves you, because in order to get past that inadmissibility, you're going to have to remain employed for about 10 years. Okay. The good thing, actually, is if an employer is looking at sponsoring and spending a lot of money on you, they might like this. They go, look, I'm spending all this money, but you know what? I've got the possibility of attracting a great employee. And you know what? The labor shortage is what it is. And maybe another day we'll talk about the extent to which right now in the US we have a terrible labor shortage. You might find employers that will be attracted to this option. Okay. So 3 potential outcomes for DACA beneficiaries. Okay. Younger DACA beneficiaries under 18 years and 6 months. Okay. So when we talk about when a person becomes a pumpkin, right? When it's basically at 18 years and 6 months. Okay. That's when unlawful presence begins to accumulate at 18 years and 6 months. Okay. So the younger DACA beneficiaries, let's say you've got, and we've had the pleasure of actually doing H-1Bs for folks like this. Well, if they've had DACA since they were 15, and they don't have any unlawful presence. So if they've had a DACA application was approved before you turn 18 years and 6 months, and you don't have more than 180 days of unlawful presence, okay? And again, that's what Attorney Maricela was saying, have your receipts ready. You've got to be able to prove it up. Say, look, I don't have that unlawful presence of more than 180 days. And the H-1B issued was issued with no finding of unlawful presence and no D3 waiver is required. So people who are like this, they can go from DACA holders to H-1B holders. They come back, no waiver, no nothing. Again, it's probably the younger ones that don't have this unlawful presence. Okay. So this is tremendous. This is tremendous because no waivers required, provided that, we meet this criteria. The second outcome is DACA beneficiaries, even those with approved applications after they turn 18 years and 6 months, can be issued an H-1B without a D3 waiver. And I don't know whether this is a reality now. I think this was a hope under Biden, and I think this is one of the changes. I think that the Department of State or all officers, all adjudicators throughout our immigration systems are being threatened to vet, to deny. So I don't know whether we have, this where even if you do have unlawful presence, if you're able to convince a Department of State officer that you should be allowed in, I think that window is closing for us. Okay. Because really, I think that the default would be this next option. Older DACA beneficiaries who are issued an H-1B with a D3 waiver. Okay. The visa officer most often will require a DACA beneficiary who applies for an H-1B to first obtain a D3 waiver after finding that traveling on DACA advanced parole still triggers unlawful presence bars. Okay, so, again, you've got to know what is it that's happening and decide what it is that you can do. So again, who qualifies for this? You've got to prepare for your immigration examination. Okay, this is like an MRI. Okay, where you expected upon arrival. Okay, before you go and saying, well, is this an option? You've got to look at the immigration history first. Do you have evidence of inspection? Okay, were you issued an I-94? Did they stamp your passport? Can you FOIA records? Okay, if you did, then you've got to know that. Okay, if you entered without inspection, where and how did you enter? Okay, that's important to know. Has anyone ever filed a family or employment-based petition on behalf of your mother or father? If so, when? If that was done before April 30th of 2001, that's like gold if you find that. Okay. Again, extending this because we just had a case like this where we found that a young person had a grandfather that was a U.S. citizen. And so that citizenship we've been able to pass on to her mother, and we're in the process of passing that citizenship onto her. So fingers crossed. So you've got to ask these questions. Where were my grandparents born? What? Ask these questions because it becomes very important. You've got to know whether you've ever been deported. Again, Attorney Maricela was saying, there's some difficult outcomes that we're seeing if you have been. What can be done? Again, you've got to know, have you ever traveled outside the U.S. on advanced parole? Okay. And as far as the D3 evaluation, before you even get to leave the U.S. and apply for that D3, you're going to have to impress upon an employer to want to spend the money on you. Okay. Update your resume. maybe you've got an engineering degree, but because of your circumstances, you're self-employed and you've got a handyman service. Well, you know what? Update your resume. Um, you've got to tell the truth, but update your resume. Um, are you involved with engineering organizations? I mean, you could be a handyman and you could still be involved with the engineering organizations. Have you done any volunteer work to enhance your professional profile? I mean, if you're an engineer and you've got your own business, who's not to say that you couldn't go and volunteer at a robotics class for elementary schools? Okay. It's the idea of just because you don't have the status, you've got the degree, you've got the know-how, you've got to find a way of keeping that relevant. Okay. And of course, with DACA grantee, you've got to be able to show your unlawful presence. Okay. Well, again, read, engage, and ask questions. This is not meant for you to go and do this on your own. And I don't want anyone telling me, oh, okay, I'm going to be leaving and doing the D3 alone. No, that's not what the purpose of this is, to show you that there may be other options. That's what the purpose of these conversations are. It's really getting into the weeds. Here we're giving you a surface, but your job is to go a little further. And I would love for you all to go and dive deep into this process. I was speaking to these people just last week. They are opening consultations. They were just opened to consultations, I think, in the San Francisco area. They're now opening it to others. This D3 is a real thing, okay? It's a real waiver. It has nothing to do with, things that, different executive orders that might have been established by other people. This is for real. This is the way we bring in folks that have had a problem. This is the way that we've normally only used it when somebody is not allowed in. Depending on their circumstance, we can bring in a D3 waiver. And so it's used to fix a problem. The little difference with you is that if you're a dreamer or a DACA holder, your problem is being here without authorization for so long. Okay. And as far as meeting the eligibility for so many of the DACA holders and dreamers, it would be great, but you do need to convince an employer to want to spend money on the process. But anyway, find out more about it. Write to us, talk to us. We are excited about this because this offers another option for some of you, especially those of you who work so hard, got a degree, for whatever reason, are not able to travel outside and get the DACA parole. Maybe you're an old dreamer or a young dreamer and DACA's not available to you. This might be a way to help this, okay? But anyway, here's our information. We would love to hear from you. We stay tuned. We will be updating this. As far as what has the Trump 2.0 done to this, I think it's become a little bit harder. I think that the passes that folks were getting may not be getting them, but it's still an avenue that's available, okay, to cure inadmissibility issues. And for most DACA holders and dreamers, the only inadmissibility you have is that 3 and 10-year bar issue, okay? So find out, read, ask questions, okay? Attorney Maricela, do we have anything else that we want to say here?
No, that's it. If anybody has questions, there is a Q&A that you can add your questions. But we are going to post this webinar, so stay tuned for that. It will be on our website.
All righty. Well, then that is all for today, and it was great talking to you all, and continue reading, finding out about it. We'll do our job to continue to talk about this, and thank God, it seems that the administration is focused on other folks. I pray and pray so hard that I think, I hope that,